Hi, good morning or afternoon, depending on where you are in Canada. It is approximately 12 noon in downtown Toronto. I'm Ryan Conlin, along with my partner, Jeremy Schwartz. We're actually really interested in to discuss an area of law that sometimes seems lost in the shuffle with occupational health and safety enforcement, and that's the potential liability of supervisors. I mean, most of us associate penalties and prosecutions as being related to employers, because, of course, across the country, the vast majority of cases are brought against employers or corporations in various statuses as employers and prime contractors and constructors and other situations along those lines. But a recent case has, a criminal case, has really brought into focus the liability of supervisors, even where the behavior or the training provided by the employer is perhaps deficient to non-existent, depending upon how one interprets the facts of this interesting case. But certainly, we thought it's a unique opportunity to discuss sort of how the criminal law applies to supervisors. So all of the advice that we're talking about today is rooted in the criminal code and in the occupational health and safety legislation, and the name of the case is Regina versus King. It is certainly probably one of the most important criminal cases to come out in a long time, because really it's one of a handful of them where there's a fairly detailed reasoning and considerations of what liability an accused can have. Next slide. As I said, basically all the advice here is rooted in concepts under health and safety legislation. You will see as we go through the King case that it's the provisions of the applicable Occupational Health and Safety Act as it pertains to confined space in this instance that form the basis for liability of the individual defendant, Mr. King. Next slide. The facts of the case are tragic. This was a public works project in New Brunswick, which means the New Brunswick occupational health and safety legislation applies. For those of you across the country, the obligations around confined space are fairly similar, perhaps somewhat less detailed than the Ontario provisions, but certainly, similar to what applies. A worker was working in what was clearly a confined space where there was the potential for flooding. There was basically a rubber plug was holding back to 32,000 liters of water. And unfortunately, that plug became dislodged and the worker drowned. And so the police investigated this, remembering it's police officers who investigate criminal negligence proceedings, and they're the ones who lay charges, not a local regulatory authority. So basically, in this instance, the accused was charged with criminal negligence causing death on the basis that he clearly failed to follow the provisions of the New Brunswick Occupational Health and Safety Act as it pertained to a confined space. Next slide. Well, I think it's important here just to pause and explain the difference between criminal and regulatory charges. And the vast majority of health and safety litigation and charges come under a regulatory regime, which most of the time is prosecuted in court. In one province in New Brunswick, most cases are proceeded on through an administrative penalty scheme operated by the local WorkSafe BC, the local Workers' Compensation Board. But for the rest of you, these are cases that are generally prosecuted in court. And basically, the charges under the Occupational Health and Safety Act only require the prosecutor to prove that the offense took place. And in this particular instance, the accident proves it. Would essentially prove the contravention. The accused failed to follow the confined space requirements. After that happens, the burden of proof then shifts upon the accused to establish that all precautions reasonable were taken. In other words, that's due diligence. So you're in a regular health and safety case. Basically, the Crown has to prove the contravention, which often is proven by the accident itself, although not always. And then the burden of proof shifts upon the accused. Jeremy's going to explain what happens when you enter into a criminal prosecution where the burden of proof is much higher on the Crown.
Thanks, Ryan. So the dichotomy between these two types of cases is as Ryan said, the initial burden, which applies in both regulatory and criminal cases, is for the Crown to prove the actus reus, that there was an act that was unlawful. In health and safety cases, typically that means there was some reasonable precaution that should have been taken and it wasn't taken, or there was a specific requirement in the act for things to be done a certain way or not to be done a certain way, and there was a breach of those specific sections in the act. In a criminal case, there's an added feature, which is called uh, uh, um, it was sort of the mental element. In Latin, it's the mens rea. And the idea here is that there's an obligation for the Crown to show not only the failure to do what was required or the doing of something which was illegal, that actus reus, but also that there was a mental element of blameworthiness to what happened. And in the case of a criminal negligence charge, such as a health and safety related criminal negligence prosecution, like we dealt with in R.V. King, what the Crown must also establish is that not only did the act or omission occur, but the defendant's actions actually have to represent a marked and substantial departure from what a reasonable supervisor, the person required to either take or prevent those actions or omissions, from taking in the circumstances of the case. And so there's a sort of an added element to this idea that a reasonable person in the circumstances of the accused would have acted differently. And having acted contrary to those reasonable expectations, that person is shown to be criminally negligent. That mental aspect of this, they should have known better, is essentially what that aspect is demonstrating. So here in R.V. King, the Crown's case was fairly straightforward, right? The accident, while tragic, happened for fairly simple reasons. There was a situation in which a worker was placed at risk, and the question for the court uh, was that supervisor, well, I shouldn't say that supervisor, but would a supervisor normally, sort of that reasonable person, have been able to know that there was a worker who was in a dangerous situation by virtue of the place that they were relative to this water and this plug and where they in this confined space. And so did they know, A, that the worker was in a confined space when the hose was turned on, thus creating this hazard? And two, should they have known that it was dangerous to have the worker in this space at that time when they're in the presence of that hazard? And so the answer is ultimately what the on the initial proof standard of proof for the Crown, simply all they had to show was there was this hazard created by the fact that there were these conditions, someone in a confined space in the presence of a situation where there was this hazard of the water and the containment. And number two, did they realize, would a reasonable person as a supervisor in that circumstance have known that precautions were required in those circumstances? And the defense's argument was blame the boss. That's sort of the title of our presentation today. But essentially, the defense was saying, I'm just a lowly supervisor. My employer was responsible for taking steps to ensure that I was trained to be a competent supervisor, which of course, for anyone who wears the health and safety hat in their organization, which I assume is most of the folks on this meeting, the employer's obligation is to ensure that a supervisor is competent. And competent under health and safety legislation across the country means that they're trained in the requirements of the act and regulations that apply. They're familiar with the plans and requirements and procedures that are going to be undertaken by the workers. They're familiar with the workplace conditions and the hazards, and that they can therefore ensure that the health and safety obligations and policies of the act and the employer's own program are implemented, and that everybody is kept safe. So this worker says, well, the employer didn't take steps to ensure that I received training in these requirements when I had a worker under my supervision in a confined space. And there were other people who were closer to this situation and the planning of this procedure, and they're the ones who are responsible, or whoever it was who was responsible to ensure that that plug didn't dislodge. They're responsible, right? Anyone but me. Now, the court's findings, sorry, bear with me. So the court's findings in this case are that the supervisor was convicted even though he wasn't trained. So blame the boss doesn't work. Well, why doesn't it work? That's the question, and we're going to take you through some of the nuances of this, but essentially the most important finding of the court we've cited here. So regardless of their professional training, right, in this case a supervisor is required to act in accordance with the standard expected of a reasonably prudent person in the same circumstances. So what the court essentially found was this supervisor knew, or should have known, that there was a worker in a confined space, that there were requirements in those circumstances to take reasonable precautions and comply with the requirements of the act and regulations, and that there should have been sort of an added awareness of the hazard that this worker faced as a result of the procedure and the circumstances. And by failing to follow those rules and take those precautions, that is evidence of negligence, because the supervisor failed to take what reasonable precautions, from a criminal perspective, that a site supervisor in those circumstances would be expected to take. And so specifically, the court finds a reasonably prudent supervisor must A, familiarize themselves with the legislated duties as set out in the act and regulations, and they must familiarize themselves with the site plan and any relevant manufacturer's safety warnings, such as, you know, this rubber stopper and how this is supposed to be steps taken to ensure it doesn't dislodge, creating a greater hazard in the workplace. Now I'll pass the conch to Ryan to sort of take you through some of what we think are practical lessons that can be drawn from the RV King case. Ryan?
Here I am. All right. So what do we learn from this case? It's on one level, and certainly in conversations I've had with clients and colleagues, you know, it's certainly gotten the most attention of an occupational health and safety case has in a while. It's kind of a relief, really, in a way, in the sense that it's not just all on the employer. People that are recognizing themselves in a management perspective have some independent obligations that, you know, that go above and beyond. You can't put it all on the employer. You have to, you know, be in a position to think a little bit for yourself. And so it looks to me, given the way this decision reads, is the judge is basically saying a blame the boss defense is not going to work in most circumstances. I mean, I could envision a case when you're talking about something that would be very site specific and very specialized, that was only within the knowledge of the employer, and the employer didn't pass that information on. This could possibly arise, particularly where a worker from one company goes to perform work at another company, and there's some hazards associated with that work that wasn't communicated, things like that. So I'm not going to say that there isn't going to be the case where a supervisor could say, look, I did everything a reasonable supervisor could do, and I certainly wasn't wanton and reckless. This hazard was completely unforeseeable and no one told me about it. So, you know, fair enough. There are going to be those kind of cases, but I think those cases are few and far between, especially when we're talking about hazards that are fairly obvious and well known. Clearly, a worker working in a space where they could be exposed to thousands of liters of water coming at them is the kind of example of something that ought to be obvious. Things that are other obvious, things like machine guarding, things like fall protection, other so-called killer contraventions that are common, obvious, that supervisors that you probably don't need to be trained for days and days to know that it's a severe hazard not to have guardrails or fall protection up where a worker could fall. I mean, that's not, you know, that is obviously not rocket science to belittle the point, but that's where that type of issue goes. So what does this case tell us about supervisors? I think it means that supervisors have an independent and concurrent obligation with their employers to be familiar with the law, site plans, and rules. I think it behooves us to, to think really outside the box and making this clear when we're training supervisors. Is it not only the employer's obligation? I'm going to get to the part about employers in a minute, but supervisors have that obligation on their own, and they could be prosecuted on their own, as Mr. King apparently was. So it's supervisors really have to understand they have they really have to have some obligations of their own. I have seen a number of prosecutions on the sort of provincial regulatory level over the years about not following provisions that are in a manufacturer's manual. And manufacturer's manuals, you got to remember, those are written by the manufacturer in many ways to prevent them from being sued. So there's all civilly. So there's all kinds of safety warnings and bold type and things that prosecutors, released under the Ontario Act, can rely upon. An employer's failure to follow a manual, so can supervisors. You really don't ever want to be a supervisor who's administering a piece of equipment that hasn't seen the manufacturer's manual. I know it seems silly, right? Because I know how many of us, we all have a car. How many of us have actually read the operator's manual for their car? Probably not a lot of us, because even though there's all kind of, but in the workplace context, you just have to do it. You don't want to be in a position where a police officer or a regulator comes to you, the supervisor, and says, "Have you read the manufacturer's manual for this piece of equipment?" No. Or perhaps even more importantly, it is the site plan, where there's a site safety plan, and you're a supervisor and you haven't read it. So it would be, so from my perspective, that's an example of supervisors having to, do your job. That they can't expect to blame the employer because the employer didn't, take the steps they probably ought to have done to ensure that the supervisor had read what was in question. Secondly, this could signal an increase in criminal prosecutions. The criminal code was amended almost 20 years ago now under the Bill C-45 provisions to make it easier to convict organizations and individuals of criminal offenses arising out of workplace safety. There certainly wasn't nearly as many prosecutions as might have been anticipated at the start of this. There's a whole lot of publicity when those provisions came in so long ago now. But we're starting to see more of them. We're starting to see police officers and police agencies being more trained in investigating workplace accidents, which have historically been viewed as the territory for provincial or federal workplace regulators, as opposed to being police or criminal matters, except in the rarest of circumstances. So we can see that could be an increase, which means, of course, and we'll see what Mr. King is sentenced to, facing real jail time, possibly federal jail time, for these kind of offenses, which have historically been dealt with by means of fines or administrative penalties. Next slide. Well, the apparent fact that this worker hadn't read the site plan and wasn't familiar with, or so he said, wasn't familiar with the confined space regulations is a red flag. I'm not trying to suggest that and I don't want anyone here to take from this case that, oh, we're shifting liability onto supervisors, not onto employers. Like, it is an enormous red flag, and as Jeremy and I wrote in our article, frankly shocking in this day and age that a sophisticated contractor wouldn't be in a position to provide proof that they trained their supervisor on confined space and had actually taken some effort to confirm that he'd actually read the site plan. I'm assuming he never had to sign off that he did, because he was there. And again, part of the issue with him being tried individually, I guess, is there was no place for the employer as a party to the proceedings. There's no place for the employer to say, well, yeah, wait a minute, yeah, we did train him, and here's the evidence. But in light of the judge's ruling, the judge's determination, it doesn't really actually matter to him whether or not the whether or not the supervisor had been trained or not. He said there's this independent obligation, but it's my view that if you had an accident like this, you could probably get the employer to be convicted on if it could be established or proven that the supervisor was never trained on confined space and no effort had been ever undertaken to ensure that he'd reviewed the site plan. That could be easily considered criminal negligence if that was in fact the evidence. The only evidence at the trial based on the judge's summary was just what the supervisor testified to, and essentially the judge said no one lent any evidence to the contrary. So we may not have a complete picture of what actually occurred, but I think this is what this really is from an employer's perspective is a reminder that you're not alone in the dock, that supervisors themselves could be found that the supervisor can't rely on the employer's, can't finger point at the employer. And, you know, as I think as we've seen over the years in provincial prosecutions, pointing the finger at the supervisor is not considered a valid defense either. Next slide. All right. So what do we have to do in terms of supervisor due diligence? What now that we can refocus on, what we certainly don't want to do is what was done in this case, which is apparently nothing. So you want to want, if you're a employer, you're going to want to have documented training on the Occupational Health and Safety Act, regulations, and criminal code obligations. I think that you're going to want to have you told your supervisors there's potentially these criminal code obligations. And I think some of you, for those of you listening, and I'm sure there are some of you that do training for workers, I think you're going to want to amend your supervisor training to include some of the reasoning from this judge. Now, I mean, we have to be cautious. This is a trial level decision from one judge in New Brunswick. But I think it's well within the spirit of how the law is written and the way the law is evolving. I think it'll be a seminal case. And I think that's the way the law is headed. But yeah, you can certainly say, I'm not saying that every judge would have found it to be this way. But I don't think there's too many judges across the land that are going to say blame the boss is okay, particularly in the context of an offense, which, you know, common sense really should not really have needed a lot of training to recognize what the hazard was in these circumstances. So obviously hazard specific training, you as an employer must show training on hazards such as confined space. I mean, you need also to ensure that supervisors are reviewing site plans. I cannot tell you how many cases I have had where there's and this is often common in construction, where there is a so-called site binder that sets out all the policies and procedures applicable to the project, but no worker has ever seen it. It's usually with workers we have this problem. It's even worse if the supervisor hasn't seen it. You have to have a process where however you want to communicate the safety information that's in the site plan, you got to prove the supervisor signed off and said he reviewed it. I mean, I'm not saying that you have to lock management employees in a room and film them reading it, but you have to at least have them say that they were provided a copy of it. And you would want to have at some point some assessment that they understood it and were following the procedures. The sign off is obviously helpful. And that gets into supervisor competence assessments. Are they performed regularly? Has anyone ever, from date of hire, ever assessed someone's competence from a safety perspective? And how is that measured here? So when you go on site, how many do we have records? Is the supervisor ensuring workers are disciplined for safety? How many safety infractions have been observed? How many orders have been issued by regulators? How many workers' compensation claims have been initiated on this supervisor's shift? Those are the kind of things, and it goes beyond. One thing I get very concerned about, and I'm just going to editorialize here a little bit, but I think it's an important point, and I've had a client that had a real issue with this. One of the ways oftentimes supervisor competence is measured is just in whether there's been no lost time claims, right? I mean, I alluded to, I'm not saying that it's not a factor that's worth considering. Of course it is. Remembering, of course, that workers' compensation claims are no fault. So just because there's been a claim, it doesn't necessarily mean there's been any safety violation. Someone throws out their back, they throw out their back. That's a workers' comp claim, but not necessarily, and most likely not, an occupational health and safety contravention. But if you start measuring supervisor competence strictly on no lost time, that potentially encourages fraud and potentially encourages the workers not reporting accidents to the Workplace Safety and Insurance Board or the Workers' Compensation Board in the local jurisdiction, which is something to which I can tell you, at least in Ontario, WSIB is very alive to that, and is and can and will prosecute employers where they believe there's some kind of fraud, and there have been cases where incentive programs and around the lost time accidents have caused employers some difficulty. And you also certainly want to meet like daily meetings that address site-specific hazards. Like you would have thought in this circumstance, before this task, there would have been a site meeting that discussed the work of the day, that there was a worker in confined space, working in a confined space, that there is a hazard associated with a potential drowning issue. How are we going to phase the work, and how are we going to deal with this, rather than just undertake what happened, which the court found to be so reckless that amounted to criminal liability. Does everything have to be in writing? I get this. I get this question all the time. Basically, I have some employers that tell me, and I don't have any reason to disbelieve them, that if we put every single procedure in writing, it would be 10,000 pages long, etc. So okay, but you certainly documented due diligence is always best. Written procedures is always best. Even if they're one-off tasks, and perhaps it's more important even at a pre-job meeting to document what's discussed, because if there's any things that are higher risk for accidents, it's one-off tasks as opposed to things that we're doing all the time. Verbal conversations, yeah, they can be admitted in court, but they're not always as effective. All high-risk issues should be in writing, and anytime there's a serious risk, you've got to have some sort of written documentation of it. Must be able to prove that workers received and reviewed training documentation. Certainly, that didn't happen in this case. The supervisor claimed he didn't read the manual, and apparently there was no evidence to the contrary of that. And of course, even verbal discipline or non-disciplinary counsel should be documented in some matters. I know that especially in unionized workplaces, there's sort of a hierarchy of discipline of verbal warning or first written, but you still have to keep track of a verbal warning. How do you know there was or wasn't one? As long as you establish that there's, and one thing I'll say, and I had a case like this, where basically the contention of the Ministry of Labor was that a worker wasn't disciplined, that who had committed a couple of fall protection offenses wasn't disciplined significantly enough, and that wasn't due diligence, and the court had no patience for that. The court had, look, there's a disciplinary system here. I, as an occupational health and safety judge, I'm not a labor arbitrator. I'm not getting into whether this person should have been fired or suspended. They had a process. They had a process. I may have fired the guy. They chose not to, but I'm not. As long as they're following the process, that's due diligence. The exact decision that the employer makes was not something that judge was prepared to accept the Crown's argument that that the discipline should have been more severe than it was. All right, the last slide I'm going to look at is training isn't always a defense. I mean, I think that, and this is the Dofasco case is a well-known example of this. This was a case where a company trained workers in a procedure where a worker was required to use a hand gripper to assist in the feeding of a steel coil into the mill. And it was clearly that was safe. If the worker had followed that procedure, it would have prevented the accident. And the worker knowingly failed to follow this procedure and was injured. And the court said, the court accepted the Ontario Court of Appeal overturning a trial level acquittal in this case, held that the equipment should have been guarded. The guarding provisions are mandatory. You can't substitute a procedure for a guard. Basically, the reason there is guarding is that occupational health and safety legislation is there to help protect the reckless worker, the careless worker, and that this worker wouldn't have been injured if they hadn't taken convenience over the mandatory provisions of just having a guard that stopped the worker from shoving his hand into the mill. So you do not like train. There are limitations on training, and that and that is. Essentially that you can't substitute training when there's a mandatory safety provision like guarding. So you always have to consider, if you're going to, there are very specific measures in most occupational health and safety legislation. If you're going to vary from a legislated requirement, and that's usually complicated and difficult to do and involves consulting experts. So it's always best, I think, best practice, of course, is to follow what's mandated in the law. So Jeremy is going to come back and take you through some of the other aspects of due diligence.
Thanks, Ryan. So, yeah, I mean, Ryan and I have dealt with a number of these cases. Some of these, two of these decisions are actually cases that Ryan was counsel on. And back in the early days, I was a lowly associate doing research and helping him from the sidelines on some of these. But I'll take you through some of these cases. And worker error is an area where both supervisors and employers may, in rare cases, be able to rely on the error of the worker to demonstrate that either the due diligence steps, the precautions that the Crown has charged the supervisor or employer for failing to implement, that those didn't apply in the circumstances, or that in the sort of parlance of the Court of Appeal, it wasn't reasonably foreseeable that this worker was going to be at risk So the reasonable precaution wasn't necessary, right? So you can't have failed to take a reasonable precaution that wasn't necessary in the circumstances, because those circumstances were so unlikely and unforeseeable to occur that no reasonable person in your situation as the site supervisor or employer would have implemented and ensured that those reasonable precautions were taken. And so the three cases we've cited here, I think demonstrate this quite handily. So the first case altogether now, this is a relatively small traveling children's theater company. They go to schools. This is one of Ryan's cases, the client of the firm. And they had I don't know if you guys know much about the entertainment industry, but essentially when you have a traveling production company, there will be things that need to be returned when the show is done. And so there were some pieces of equipment and materials that had to be returned to a metalworks facility when the show was done. And altogether now had a driver and a helper who was just another employee, technical worker within the company. And they were traveling together using sort of a commercial panel van that you might use to move back when you were a student, or helping someone to move a small apartment. And if you're familiar with those trucks, the back of them has sort of a metal ramp that can be extended from the back of the truck. And so when this commercial van was driven to various locations to return things when a show was done, in some cases, they would have to load things from the truck to the loading bay of a building. At some buildings, they would use this extendable ramp in order to bridge that gap between the truck and the loading bay of the building. And in other locations, there would be a metal deck that could be extended or used that was sort of on site at the location, at the building. And so that's exactly what it was here. So this particular location, this metal workshop, had been a place where consistently and in the past, altogether now's workers were able to use this on-site deck to bridge the gap and the unlevel surfaces between the back of the truck where they're taking the materials and the deck. And so these workers were expected by the company to show up on site, to back the truck up so that it was relatively close to the loading dock of the building, and then to wait for the workers at the building from this metal shop to bring the deck and lay it down so that they could go back and forth and carry the materials off of the truck. Now this had been, I guess, at the end of a long day. It's not entirely clear from the decision, but essentially it would appear that these workers decided they didn't want to wait. And so the driver of the truck had the worker go behind the truck to lift up this metal ramp that's part of the truck and hold it up while he was going to reverse the vehicle. Now, normally when they're at a facility that doesn't have a metal deck and they have to use this ramp, the process would include the help of another worker. And that worker would act as a signaler for the driver who's reversing the vehicle, and the worker who's standing ready to sort of lift up and lower that ramp would be away, sort of out of the way of the reversing truck, waiting for the driver to bring it close enough that they could bring down the ramp. For reasons unknown, the driver in this case reversed while the helper, without the help of a signaler, while the helper was standing between the tailgate of the truck and the loading bay of the building. It's really only by some miraculous intervention that this worker wasn't crushed and killed. They were pinned between the tailgate of the truck and the building. They suffered severe injuries. Again, miraculously, by end of trial, apparently they had effected a full recovery, but not after missing months and months of work and going through what I must assume is significant pain, suffering, and recovery. So this employer was convicted, though, of failing to provide information, instruction, and supervision, and having a safe procedure for using this ramp that comes with the truck and ensuring that sort of the safe procedure, which would have included a signaler and the worker standing out of the way, was followed, and that everyone was trained on that procedure. They were convicted at trial on that basis, even though there was evidence at trial that at that building, there was no reason for these workers to be using the ramp at the back of the truck. In fact, they had in the past consistently waited for these the metal works company workers to come and lay down the deck that was at the building. Okay, so it was the company didn't expect anyone was going to use that ramp, and that's the reason why on appeal the company was acquitted. So in this case, essentially, what the appeal court found was the employer was not obliged to have a safe procedure training and instruction on that procedure for using this onboard ramp when there was no reason to believe the workers were going to be exposed to that hazard or using that ramp in the circumstances. And there's what I like, there's one particular quote in that decision, which I like, and I think it's quite suitable here. A company does not have to train the bookkeeper on safe use of the forklift. And so essentially that sort of dumbs it down a little bit, but maybe it's an oversimplification, but essentially where you can establish that it's not reasonably foreseeable that the worker will be performing that task or exposed to that hazard, then you don't have to ensure that you provide the procedure and the training, instruction, and supervision on that procedure in those circumstances. In Accurate Electric, essentially these workers, if you've ever seen a large construction site, there might be a crane that is quite large and it's erected when the work has to be done, and then of course the crane has to be disassembled once its work is complete. So the workers were disassembling this crane at the end of this work, and a worker fell to his death tragically from an area that he ought not to have been in. So the work that he was doing, there was no reason why he would have been anywhere near the place that he was. Also, the area where he was working was described as a steel cocoon. So if you imagine a sort of not unlike my background here, a matrix of interlinked and connected metal structures that would have made it very difficult, if not impossible, for a worker to have fallen, even if he was in that area. And again, there was no reason for the worker to be there during the work that they were doing. And so ultimately what the court found was it wasn't reasonably foreseeable for the employer in this case, or if it had been a supervisor charged, likewise, it wouldn't be reasonable foreseeable that the worker would be in that area. And so it wasn't necessary to have reasonable precautions to ensure the worker did not fall from an area that he had no business being in the first place. The third case referenced here, the auction reconditioning, as the name of the company sounds, this is a company that basically cleaned and reconditioned vehicles before they were sold at auction. There was an 18-year-old cleaner working, this was his fourth day on the job, and he was told when he was hired, and in fact was told on that morning, the fourth day when this incident occurred, you're not to drive our vehicles. He was expressly told, and he admitted that he was told the same. There were specific groups of workers who were trained as drivers and assigned to do the driving of the vehicles from the area where they were cleaned to the area that they were parked when they were ready to go. And those workers had to have licenses, and there was a policy that says you can't drive a vehicle unless you have a license on the property. He admitted at trial that he did this at the spur of the moment, even though he knew the rule was that he wasn't supposed to drive at all. So this company, bizarrely, was convicted at trial, despite all of that evidence, and ultimately they went to appeal that conviction, and they won the appeal. And the court cited a well-known case in RV Inco, and I'll say it to you. I'll just sort of give you that little excerpt. So to ask the court to accept that an employer should be required to contemporaneously supervise an employee for each task is an absurd result. And so this is where the Crown actually argued that it was a failure by the employer to ensure that the supervisors were monitoring basically at all times to ensure that only people who had been directed and trained to do the driving would get into a car, even though this worker, and the evidence was unrefuted at trial, everyone, including the worker, confirmed he had been told that he was not supposed to be driving. And so here the appellate court found the Crown failed to prove that the employer was obliged to provide the information, instruction, and supervision in driving and this policy to a worker who was told he wasn't supposed to be driving and acknowledged that he understood that was the rule. So these are those worker error cases where either the worker is not going to be doing the thing or being exposed to the hazard, and so there is no need to have that precaution or training or supervision in the first place, or where a worker is expressly told and trained to do it a certain way, and in the absence of those guarding cases that Ryan talked about, where you must have a guard regardless of training, they're trained, they're competent, and they understand, and that training was sufficient, and they ignore their instructions, this training that's been provided. And so how could the employer, unless they literally had a supervisor standing beside someone at all possible times, how could they possibly have taken any further steps to reasonably prevent the worker from committing that error? Some of the things that can come up sometimes in cases dealing either with training counts or general duty counts. So a training count is that obligation to provide information, instruction, and supervision, having a procedure and training workers on that procedure and the hazards of the workplace. The general duty clause is sort of that catch-all. In Ontario, it's 25(2)H is the section of the Act. It essentially is that requirement to take all precautions reasonable in the circumstances to prevent the infraction or to protect the worker. And so that's the essence of due diligence. And when there isn't a specific requirement in the Act or regulations to apply to a circumstance, that catch-all general duty clause, the basket clause, as some might call it, captures the employer's and supervisor's obligations to take all precautions that a reasonable person would take in those circumstances to protect the worker and comply with the law. Now, industry standards can be an important way to explain to a court what precautions would be reasonable in the circumstances. So if there's a method, a procedure, a practice, a certain way of using or certain kinds of PPE or something like that, the fact that in general, this is an industry standard practice that everyone acknowledges and recognizes is the safe and proper way to do something, that can be persuasive evidence, although that the employer has or the supervisor has done things in a way that a reasonable person would do. So a reasonable person would be aware of the industry standard way of doing something, if it really is an industry standard, and they would comply with that standard, expecting that that standard has been developed and accepted because it is the right way to do things and it's safe. Now, again, that's not a get out of jail free card, because that's not going to be binding on the court, but it may very well be persuasive evidence of what that reasonable standard would be. In some cases, standards and codes are actually referenced directly in a statute or regulations. So often CSA standards are referenced directly in the regulations. And then in that case, it's not a question of external standards, but direct. But in other cases, where the work that you're doing relates to or is governed by, simultaneously governed by other statutes and codes that have their own enforcement mechanisms, compliance with those requirements is actually forceful, persuasive evidence that what you're doing is in compliance with what a reasonable person would do under the health and safety legislation. So the expectation is, if you're constructing something in accordance with the building code and you don't comply with the building code, then you're not taking reasonable precautions in the manner in which the work is happening, because you're required to comply with both of these codes and standards simultaneously. Now, of course, the reverse is also true. If you are complying with that, then that might be persuasive evidence that you are doing what a reasonable person in the circumstances would do. And finally, does an accident prove that the person has not been trained, or that the training was insufficient or in some way deficient. And so we have seen, Ryan and I have seen so many cases where the Crown is saying that the fact that the accident happened proves there must be a contravention, right? Without no offense or anything, but often it seems that if there was an accident, it must be someone's fault. Someone, the employer or the supervisor, must be guilty. It's just a question of what they're guilty of doing or not doing. That seems to be the approach often in training cases in particular. And there are so many cases, even just the 3 that I took you to, where that's not been the case. And there are dozens of others that really that approach, we just don't agree with it. And so I think, frankly, we're right. And the key question in these cases, these training cases, which really relate to providing information, instruction, and supervision, and having those plans or policies or procedures that are in place and making sure people are aware and trained on them and that they're being enforced. Those cases really come down to, in the first case, was it foreseeable that the worker would be engaged in that activity or would be in proximity to that hazard that's being created in the workplace, whether related to their own work or the work of others or the site conditions or the plan for the work that was going to be undertaken. And number 2, was the worker trained? And if the training and procedure received was adequate. And so, although it is important to have the, a box checked, confirming that a worker has seen a policy or has received, task-specific training where it is reasonable to have that kind of training. Often, the best evidence of the quality and sufficiency of training will be the actual training program, the training materials. So it's a good idea, if you want to help your lawyers help you defend a case, to ensure that when you're sending workers to training, you not only keep a copy of their certificate, but you obtain a copy, just for record purposes, of the training materials that they went through, or even just a syllabus, a course outline from the training provider, if it's from a third party, of what it was that they were trained on. And of course, if they're tested, maintain copies of those tests, because that'll demonstrate that they had to review and understand the material to which they were exposed. So now I will open up the lines for you folks, for Ryan and I to answer questions that you might have. If you're not sure how to do that, at the top right-hand corner, you'll see a little orange arrow, which can expand the control panel if it's not expanded. There's a place for you to add your questions. And so if you want to take a few minutes and do that, I will just check the queue and see if we have any good questions now, and we'll take you through it. All right, so we have an earth-shattering question so far, which is, will we be able to receive a copy of the webinar? Yes, so as we always do, we will be posting a video, a copy of this program, and the slides will be provided in a link for anyone who responds to a feedback survey, which will take you literally 1.5 minutes to complete. And we really do appreciate those because they help us to plan for future programs and to make improvements. And so in exchange for you completing the feedback survey, the slide link will be provided to you. So here's a good question for Ryan. How in-depth does supervisor competency need to be? Is anything better than nothing? And just for the sake of it, this particular individual works at an industrial workplace, not on a construction site. I know a lot of our cases today have been focused on construction, but of course the principles are similar. So
Yeah,
Ryan, you want
to? I mean, obviously something is always better than nothing, but a Band-Aid that's about to fall off isn't much better than no Band-Aid at all, shall we say. No, but on a more serious note, How in depth they have to be is really dependent upon how much safety, on how much risk that particular.
Ryan, I think I've been unfair. I noticed that the same person added a word which might be relevant. So I think they're asking, how in depth does the assessment of supervisor competency need to be? There we go. Slightly different.
Yeah. So how in depth does the assessment of well, I think that the assessment at least needs to cover sort of the basics, like what exactly is the supervisor doing their job with respect to safety? Are they, first of all, are they aware of the hazards? Have they been trained on the hazards? Are they following disciplinary procedures? Are they reporting high risk near misses? Are there issues that are arising? But yeah, you really like have they signed off that they've reviewed all the safety procedures that are that are relevant? I mean, it doesn't have to be anything huge. I think most decent supervisor competency assessments could be on a 2-page sheet. Doesn't have to be much more than that. But it's the key thing is have a process and follow it. And just doing it once isn't enough. Like an annual assessment is probably best.
And Ryan, sort of, I don't have the answer to this, so I'm wondering if you know. In the King case, was there a parallel health and safety prosecution?
I don't know the answer to that. Not that I'm aware of, but I don't know.
Yeah, I mean, Ryan and I, just so you guys understand the practicalities of this, often, well, in the rare cases where this might happen, often one case will be stayed pending the adjudication of the other, but not always. And typically, the investigations will be run parallel, and the Ministry of Labor and the police might not do much talking to each other. They may or may not. So, although they can share information, they might run, they will likely run entirely independent investigations, and neither of them is obliged to tell you that they are going to be laying charges until they've reached a certain point in their investigation. And so, obviously, there's an obligation to cooperate as those things unfold, just sort of as an aside.
Yeah, and another piece of it, which is interesting, most unlike in the highway traffic context, right, where you'll see parallel charges of, let's say, criminal charges of impaired driving, and then maybe a careless driving charge of a provincial charge under the Highway Traffic Act tried at the same time. You can't do that under the laws that currently stands with a OHS case and a criminal case. So they're not, unlike in like where they probably could easily be tried at the same time. They just aren't.
So, I'm not seeing other questions yet, but we'll give folks. I'm sure there are some people frantically typing to get their burning questions before us.
Yeah, while we're waiting for that, I mean, I think just the one comment I want to make is that it is pretty common these days, especially in Ontario, for individual supervisors to be charged. I'm seeing it is anecdotal, but it seems more and more. Am I seeing supervisors charged? I'm seeing workers charged. There is seems to be a focus on from prosecutors and just enforcement people in general of going just beyond the employer. I think regulators are starting to take the perspective that we're going to start holding individuals accountable. And certainly we've seen some changes in Ontario around increasing the fines towards officers and directors. Whether that means we're going to start seeing a bunch of C-suite prosecutions remains to be seen, but it's a trend to keep an eye on.
That's a good point, Ryan. I mean, remembering that Bill C-45 came out after the West Ray mine disaster, and it related to, in that particular case, there were, I guess, findings following inquests that the corporate, the sort of the C-suite level, like the more senior folks at the company, had made certain decisions from a cost-cutting perspective not to implement the safety precautions and to spend the money to ensure that things were done in a safe manner. I think that was one of the big reasons why Bill C-45 came out, if I'm not mistaken. So it's now that we've seen these increases in fines, in some cases, 10 times what they could have been fined before, 15 times what they could have been fined before. Officers and directors going from $100,000 to 1.5 million in Ontario recently being the increase. Maybe there will be sort of a test case of that C-suite level when it comes to sort of from a top-down perspective. Are we creating that culture of health and safety? Are we making decisions that are safety focused? or is the bottom line our primary focus? So that's time will tell, but yeah, that's a concern.
All right. Are there any other questions, Jeremy? Or are we?
I'm not seeing any other questions. So that being the case, Ryan, you want to sum it up?
Yeah. Well, thanks everyone for joining us today. We appreciate it. We anticipate the Supreme Court of Canada is going to be releasing its decision in the Ministry of Labour versus Sudbury case, which Chairman and I argued at the Supreme Court last year. For those of you who either are in construction or hire construction contractors, that will be a major decision in terms of what the liability of owners are for accidents on construction projects. So when that decision is released, we will have another webinar to comment on that. Other than that, we thank you for joining us, and we'll be in touch, but we'll see you soon.
Thanks so much, everyone.